Thank you everyone for taking time to attend the Asia Pacific Advertising Year in Review webinar. I'm Justina Zhang, Asia Pacific President of GALA and Senior Partner of TransAsia Lawyers. 2020 has been a challenging year for everyone. The global pandemic changed almost every aspect of life and business, including advertising and marketing. The regulators' response to the pandemic varies across the world, in many cases including renewed focus on enforcement, new focus areas of concern and scrutiny, and even new laws and regulations. In the next 15 minutes, our Asia Pacific fellows are going to share with you the key advertising law developments in their regions. We will have a Q&A session at the end. In the meantime, please feel free to use the chat feature to present your questions to the host and the panelists. Let's get started.
Okay, this is Angus Forsyth of Hong Kong, GALA member in Hong Kong. I'm now moving on to our first treatment in doxing, which is the recording of personal data and sharing it on the internet. On the 9th of October 2020, a former Hong Kong telecommunications worker was found guilty of doxing. The offense was the saving by the defendant of personal data of 29 individuals and recording 63 addresses without the permission of his employer. On the 9th of October 2020, we can move on from that. The actual criminal charges were obtaining access to a computer with a view to dishonest gain for himself or another. That's the crimes ordinance. A further charge of disclosing personal data without consent. The defendant shared the information related to the father of a police inspector to an online doxing group. The background was that the court was informed that 2,000 police officers and 1,000 families had been doxed, cyberbullied, and harassed. The offences were committed in July 19 to September 19, and the court was found to have used the Hong Kong telecommunications system to use in the searches were obvious breach. The defendant admitted to imputing some of the information as incorrect, accurate personal data and attempted to correct it, but this was not believed by the court. We move on to the security law in Hong Kong, and we now need to look closely at the relevant issues for the offences committed under the new national security law. The basic thrust of the new law is designed to stop the following activities by way of specific articles under the following headings, and to provide that each renders the person concerned as guilty of an offence. Then there's secession, Article 20, organizing, planning, or committing separating Hong Kong from China. Then Article 22, subversion, any person organizing, participating in the overthrow or undermining of the basic systems of Hong Kong SAR. The next one is Article 24, and Article 24 is to terrorist activities, organizing, planning, committing, participants, or threatening to commit serious violence. Article 29, collusion with a foreign country or with external elements to endanger national security. Article 43 is generally applicable and provides that the law enforcement authorities, including the Hong Kong police, when handling any cases concerning offences, can require a relevant service provider or a person to reveal electronic device content. The next issue under the security law, which is not yet in place, as a matter of fact, for this particular slide, is advocating the independent separation of Hong Kong, what can be taught in schools. And there is one issue now where a teacher who was participating in a syllabus replanning and included a slide in what he was putting into the program, showing the Hong Kong independence movement, which is then legal but is now illegal. And as a result of his inclusion of this slide, this teacher has been deregistered for life from being a teacher in Hong Kong. This is a very serious matter and is being taken very seriously by the community in Hong Kong, and we have to see which way the government wants to go on this. So under the basic law, Hong Kong is an integral part of China. If there's any suggestion that this is not the case, then that is now an offense under the new security law, but it was also an offense under the basic law, although much more tenuous in view. And we'll have to see how the court would demonstrate this if the teacher is going to apply for judicial review or in some other way to have himself restored to the registration under an appeal system which is available for him to implement. So that is the end of my presentation. Thank you very much.
Thank you, Angus. I'm Chie Kasahara, Senior Partner of Atsumi and Sakai, Tokyo, Japan. I would like to explain a coming change of advertising in healthcare sector in Japan. First of all, I explain the current regulations. Generally, the Act Against Unjustifiable Premiums and Misleading Representation, AUPM, regulates advertising in Japan. Unjustified or misleading advertising is prohibited. The Secretary General of the Consumer Affairs Agency may order the advertiser to cease the misleading representation and take the measures necessary to prevent the occurrence. In addition, the penal charge system is there, and the Consumer Affairs Agency may order the advertiser to pay 3% of sales value for up to 3 years of the represented products or services if the value is more than 50 million yen. For the healthcare sector, the Act on Pharmaceuticals and Medical Device additionally prohibits false and exaggerate advertisement for pharmaceuticals and medical device and advertising for unauthorized drug. Violator of prohibition of false or exaggerated advertising or advertisement of unapproved drug may be punished by imprisonment with labor or work for up to 2 years, a fine not more than 2 million yen, which is equivalent 20,000 US. Different from AUPM, the Pharmaceutical and Medical Device Act does not limit the subject of the advertisement, so not only manufacturer of pharmaceuticals, but also the media that carries advertisement could be also punished. The range of punishment for media is same as the advertiser or manufacturer of the pharmaceutical and or medical devices. The Pharmaceutical and Medical Device Act was amended recently A new penal charge system was introduced due to the problem of false exaggerating advertising in relation to healthcare sector. The Minister of Health, Labour and Welfare shall order the person who has committed the violation to pay 4.5% of sales value for up to 3 years of the represented products. So the caution is required if you advertise pharmaceutical, course drug, certain type of cosmetic and medical device in Japan. Thank you for listening.
Everyone, my name is Denise Mirandah from Mirandah Asia here in Singapore. And I'm going to take you through a few developments in the Southeast Asian region, mainly Singapore, and also some new legislation that's come up in Indonesia and Vietnam. I'll just give you a quick roadmap of where we're going. I'll give you a quick overview of the annual report that was released by the Singaporean Advertising Authority, and then a quick advisory from the Advertising Authority specifically about COVID and COVID-related advertising. We have the law coming into effect on plain packaging for cigarettes, and new guidelines on price transparency, which is going to affect marketing and advertising, and followed by the two new legislation one in Indonesia regarding e-commerce, which is very important, very large market in Indonesia, and stricter anti-spam regulation in Vietnam. So the overall trend for Southeast Asia is we are trending towards more consumer protection. I think previously the emphasis has really been on economic progress, perhaps at all costs, including consumer protection, but we are trending towards more consumer protection for more efficient markets. So I will proceed now into the actual slides. So first up, we have the short report from the Singaporean authority. As you may know, Singapore is a self-regulatory environment with regards to advertising, but we do have a code. And the report states that there has been an increase in complaints this year. So they've put that down to more consumer awareness and also their own outreach programs, which the authority itself has conducted in terms of workshops and seminars. So we have 359 complaints made in 2019, which is only 65% increase on the year before. And the jump really has been with regards to a few sectors in particular, which are repeat offenders, finance, restaurants and food and beverage industry, and beauty, some of the main complaints that have been received. I think also the telecommunication sector in terms of data packages and mobile data and the reliability of those packages. Going on to the next slide, we have an example really of a claim in the finance industry. An advertiser, a finance company, a remittance business actually did advertise that there were quote unquote no sneaky charges. However, they did not reveal that SWIFT fees were to be deducted for a customer's transaction. So what the complaint was made, and the authority said that this is a misleading claim. If there are extra charges at either end of the transaction, it needs to be said upfront, and you can't claim there are no sneaky charges, and then the customer is surprised with an extra charge at the end of the day. So from misleading, we go on to something more on the moral side of things. We have an example of a racially insensitive advertisement. Here we have the four main racial groups represented, We have a lady up the top in pink. This is an advertisement ostensibly for an e-payment system that is kind of meant to be universal in application. So you can use it down at the hawker store or wherever you are, really. And we've got the four main groups represented. We've got a Muslim lady in a headscarf. We have also an Indian man, and down below there's a Chinese man. So they're all portrayed by the same actor, and apparently he's a Chinese comedian. He's ethnically Chinese, and he's quite popular amongst the Chinese-speaking community. However, I think the minority races, so mainly the Malay and Indian communities, felt that this was racially insensitive. And actually the broader community, especially young people, thought that the ad was racially insensitive. And why could you not get 4 different people to enact this particular ad? Because, you know, the Indian man is depicted, he's a Chinese man, so he has brown face on. And, you know, we have been sensitized to things that are happening outside of Singapore. So even though we ourselves do not carry the same history as, for example, the United States, we are still sensitive to those, you know, social laws that are changing. And this sort of thing is deemed quite unacceptable, especially amongst young people. So this really highlights the need for us to, you know, be sensitive and also to do the necessary ad clearance. I think that is very important, and this would have had to go through levels of clearance, and still it wasn't caught. So I'll just quickly move on to the next slide. Interestingly, ASAS said that this didn't contravene advertising guidelines, but was in poor taste. But the backlash was extreme, and so even though ASAS has deemed this acceptable, I think it really is in poor taste, and it didn't come across well in the public arena. So quickly, restaurants and food and beverage very much also complained about, and mobile phone operators. I think I'll just skip over this. Right, we have also, moving on to the next advisory from ASAS, the authority has said that any COVID-related advertising has to be truthful. I think there was a clear directive from them quite early on in April. So early on in this lockdown process, they said, you know, don't put out, especially medical products that claim to have therapeutic values that don't actually have scientific backing, especially with all the anxiety around COVID. It was important for them to put this out, and I think they did the right thing. Interestingly, they also say, put out messages that the government is handling this well, positive messages about the government's handling. So that was something in the news. And we also have, moving on now to something different, we are going on to the plain packaging law, which I think I may have spoken about in previous webinars. It's actually come into force in the middle of this year. So that will have significant health benefits. We already had, as you can see on the bottom right corner of the slide, we had the cigarettes behind a closed display. So they weren't out on open display anyway. You had to go to the counter and actually tell them the name of the brand that you wanted and the type of cigarette you wanted. So perhaps this won't have a huge impact, but any step is a step in the right direction for cigarettes. The question is, what's next for plain packaging and advertising and marketing with regards to, for example, breakfast cereals, processed foods, infant milk formula. These are things that are coming up, I think, in terms of plain packaging. already being talked about in the US and the UK. So the next thing I'll quickly touch on is the price transparency law. We have new guidelines from the Competition Commission, which govern the misuse of terms like free, and advertising a product as being free when conditions are actually attached. That's going to be regulated now. Sales should be genuine sales, so no continuous fire sales that go on for throughout the year. If it's a fire sale, it should have a limited duration. If it's a clearance sale, it should have a limited duration, closing down sale, and so on. So no drip pricing. For example, if you go on to buy an airline ticket, it shouldn't come with additional booking fees, fuel surcharges, credit card fees. The sale price that they advertise needs to be the complete price, so that consumers are not misled. No comparative advertising, which is misleading. It must not be false or misleading. It's still allowed, but not. It has to be truthful. And this is an example of a typical fire sale that goes on all year round, which won't be allowed anymore. So no false discounts. As I've said already, I think, and with some elaboration on a misuse of the term free, trial periods, for example, you need to notify the consumer that this date to this date is the trial period, and any subsequent use of the service or product needs to be paid. So all that needs to be very clear up front. Yes, I'll just quickly skip over the enforcement. I think it's going to trend towards greater enforcement. So we'll watch the space about the enforcement of these regulations on price transparency. And just quickly, like on Indonesia, it's a huge, huge market, especially e-commerce, especially mobile payments. So there has been trend again towards more consumer protection, and this now is an actual law that talks about advertisements not being misleading, not containing false claims, and we have to watch the space on the actual enforcement and actual regulations that come from this main overarching law. So we'll watch for this implementation in the future. Vietnam, we have stricter anti-spam regulations. So, you have to opt in, basically. It's not that they can just collect your data and then, you opt out. You have to actively tick the box that says you want to receive communication from a particular vendor. So that is a quick overview, and I'll hand it over to Julika. Thank you very much.
Great, thank you. Hi, I'm Julika Wahlmann-Smith from Hesketh here in New Zealand. So I'm going to give you a quick overview about advertising developments in New Zealand over the last year. Like in most places, this year has been dominated by COVID-19, and what we've seen is not a huge change in regulation in advertising, but more of a focus on ensuring that advertising is socially responsible and protects consumers from undue fear or confusion. To start with, what we had is basically a barrage of government advertising, really focusing on the message here in New Zealand, which was to be kind and we will get through this together. So we actually saw a commercial advertising taking a bit of a back seat and not such a large amount of new advertising coming out into the market. But moving on from that, we did see the continuing trend of the shift of advertising going online, in particular in social media and the use of influencers. So what I'm going to run through today is just quickly the impacts of COVID-19 in advertising, some new guidance that the ASA has issued for influencers, and what's coming up in New Zealand in the future. So once COVID hit New Zealand, there was a raft of emergency legislation that was passed, but as I just mentioned, it didn't relate to advertising. Instead, what we saw was that our Advertising Standards Authority, our ASA, published guidance to assist advertisers to comply with the existing codes that we have. And they focused that guidance on areas where they were seeing the largest number of complaints, which was around therapeutic and health products or services and alcohol promotion and advertising. What we saw in relation to therapeutic and health products and services was really that focus on that only specific products that were defined in our Medicines Act could claim to have a therapeutic purpose in advertisements and ensuring that any health claims were sufficiently substantiated. We did have a few examples. For example, a homeopathic website had on its website under the part that was called the season of coronavirus, that homeopathy had a 98% success rate in the 1918 flu epidemic. The ASA found that the average consumer was likely to believe that the homeopathic products that were listed would also help with COVID-19. So the content was swiftly amended with the more offensive content removed from that website. Another area where there was an increase of complaints was in relation to alcohol. And so that brought the ASA to put out guidance, just making sure that advertisers were reminded that they had to obey a high standard of social responsibility in advertising alcohol, and things that wouldn't comply with that standard, including making any express or implied claim that alcohol is necessary or essential to survive lockdown or the pandemic, promoting drinking games as a way to pass the time in lockdown, encouraging excessive volume purchases because of limited access during lockdown, or making therapeutic claims about lockdown, for example, that alcohol prevents, treats, or cures COVID-19. So with social media being used increasingly as a tool for advertising, way to advertise, we did see at the start of this year a few more high-profile influencer decisions that caught the ASA's attention. The first of which was content put up by Art Green, who shot to fame in New Zealand by being our very first bachelor on the reality TV series. He's remained more famous than others, as he's still with the person that he met on that show. So I suppose, like many reality TV people, he has turned to Instagram to promote products as a way of supporting his living. In this particular post, he was holding a Heineken. He did use the hashtag SP and Heineken, but the ASA took the view that this was not sufficient to indicate that the content itself was an advertisement. The ad was withdrawn when the complaint was made. Another example is the one that's on the slide now. This was a post from Simone Anderson, who's also quite a well-known influencer in New Zealand. Again, the complaint was made that it was not sufficiently transparent whether this was advertising or not. After the complaint was made, she did update the post to include hashtag gifted, but again, the ASA commented that that was not sufficient to identify this as being an advertisement. So basically, on the background of these decisions, what happened is that the ASA decided to put out more guidance in relation to use of influencers and for influencers themselves when they're placing their posts online. The main gist of this is that all advertising content must be easily identifiable from a consumer's first interaction with that content. So consumers can't be required to search through the content to try and work out if something's an ad or not. It must be immediately apparent to them. As part of this, the ASA introduced new labelling requirements from 14th of September this year. It also reminded everyone that all parties to the advertisement are responsible, so the influencer as well as the advertiser. The new labelling requirements are really to help reiterate that a consumer needs to know immediately that they are dealing with an advertisement. The label is required to be prominent, it must be easily understood, and the ASA suggests using ad, advert, or advertisement. It must be separate from other labels and hashtags. Of course, if you just had it within 20 other hashtags, it might not be very apparent to someone that they are in fact dealing with an advertisement. The label should be appropriate for the device and the channel on which it is used, and each segment of a story that contains ad content and each separate post must be labelled. So what's coming up in New Zealand? So we have very recently just voted in our general election, and as part of that we also voted on a referendum as to whether cannabis should be legalised in New Zealand or not. We are expecting the results of that shortly, and if it is passed, it will of course create a new market in New Zealand along with new regulation in relation to advertising of cannabis. We expect that if it is legalised, that any advertising will be very restricted, similar to advertising cigarettes in New Zealand, which is also very restricted, but it is an interesting area to see how it develops. Another area that is on the horizon is greater regulation of organics. So there has been a draft bill that's been introduced which would provide for stricter guidance as to how products can be certified as organic and who can use the term organic to describe their products, just generally, and including, of course, in advertising. So I think it is only at its early stages at the moment, but I think we will see more movement in this area, and it again will be an interesting one to keep on top of to see how it develops. So that's it for New Zealand. Thank you very much.
My name is Sharad Vadehra. Thank you, Julika. My name is Sharad Vadehra. I'm from the firm Can and Krishme in India, and I would like to give you some, some interesting tastes from India. Allow me to present you my very first slide. Just give me a second. Yeah. Okay. We have the establishment of the Central Consumer Protection Authority in India. This was much awaited, and it came around in 2019. CCPA is to promote, protect, enforce the rights of consumers as a class. It also will conduct investigations into violation of consumer rights, institute complaints, prosecute, order discontinuation of unfair trade practices, misleading advertisements, impose penalties on manufacturers, endorsers. We will be seeing more of them in the coming slides. Publishers of misleading advertisements. Now, what are the proposed guidelines for prevention of misleading advertisements? There are draft guidelines which have been notified, and essentially they relate to prevention of false or misleading advertisements. It also ensures there is due diligence carried out for endorsements. Now, remember, India is a huge country, and we have a prolific Bollywood industry. So the number of Bollywood stars that come around from India, you just can't count them on your fingers. Now, these Bollywood stars end up as becoming endorsers, and there were a lot of issues in the past where the advertisements were being endorsed by these well-known endorsers, the Bollywood stars. So now these guidelines will actually bring about what are the steps and ways how these particular endorsers can be held responsible. At the same time, they could, manage the way advertisements are being endorsed in India. So an advertisement should contain truthful and honest representations, not mislead by exaggerating capability, performance, service of the product, not offer rights given to consumers by virtue of law as a distinctive feature of the advertiser's offer. So something which has already been given by the law need not be given as a distinctive feature of the advertiser's offer, not suggest that the claims made in it are universally acceptable if there is a significant division or informed or scientific opinion performing to such claims, not to be offensive. Now, this is important. We'll be covering this particular issue in one of our videos, which I'm very sure should be playing in the coming slides. Not be offensive to generally acceptable standards of public decency in India, and should not contain material which is likely to cause grave and widespread offense to the public. Very important. Okay. Non-imitation of advertisements. Now, this particular provision on comparative advertising has come up and very crucial for a country of the size of India. Advertisements containing comparisons with other manufacturers, suppliers, producers, or with other products, including where a competitor is named, are permitted. Note, they are permitted in the interest of promoting competition, where the features of the competitor's products and advertisers' products are specified clearly. The subject matter of the comparison is not of such nature so as to confer an artificial or unjustified advantage upon the advertiser. Nature of comparisons is such that they are factual, accurate, and capable of being substantiated. So this actually puts at rest a lot of issues which were there in the past when, because of comparative advertising, two particular companies would end up in a court battle, and issues which have already been clarified out here used to be discussed at length in the court. Now this particular issue has been set at rest, and a lot of upcoming legal battles may not ensue in view of the guidelines that have come up. Bait advertising and advertisement shall not seek to entice consumers to purchase a good or service without a reasonable prospect of selling the advertised good or service at a price offered. There should be adequate supply of goods or services to meet foreseeable demand generated by such advertisements. This is very common in India. There'll be a period of sales in India where the prices of goods or services are brought down. But when a consumer goes and tries to purchase or avail these services, adequate number of the product or the services are not available. And this results in something known as bait advertising, which is now having guidelines for it in India. Now going to the next slide. Yeah. Surrogate advertising, another very important issue here back in India. Now, give you a little bit background of what is actually surrogate advertising in India. For example, alcohol. Now, alcohol and its advertising in India is banned. So, huge population consuming alcohol, but you cannot advertise alcohol in India. So, the only way the manufacturers or people marketing alcohol is by way of surrogate advertising. And how do they do it? So they would be coming up with an ad with the same brand name of the particular ad, a particular alcohol, and they will be using that particular ad for a mineral water bottle or for playing cards, and in the process also advertise the brand of the alcohol. And this was allowed. And now we have guidelines on that which were missing. So the guidelines say advertisements for goods or services whose advertising is otherwise prohibited, like I said, alcohol, or restricted by law, shall not circumvent such restrictions by purporting to be advertisement for other goods or services, such as playing cards, the advertising of which is not prohibited or restricted by law. Criteria. Now, what is the criteria to judge whether the ad is a surrogate ad or it is not a surrogate ad? Whether the unrestricted good or service is produced and distributed in reasonable quantities. This is important. Having regard to the scale of the advertising in question, the media used, and the markets targeted. So if you are advertising playing cards as, say, for example, alcohol, the number of the playing cards that is now coming into the market should be substantial. So it should not be a mere limited number of playing cards. Second point, second criteria, whether there exists in the advertisement any direct or indirect indication suggesting to consumers that it is a surrogate advertising. This is another criteria. And another one, the mere use of a brand name or company name that may also be applied to a good or service whose advertising is restricted or prohibited is not a reason to find the advertisement in question objectionable. In other words, there used to be disputes in the court of law where a competitor may come up with this particular issue that the playing cards are using the same brand as that of an alcohol, the advertising of which is prohibited. Now, this lays at rest such issues before they go to the court of law. Honesty of statements and due diligence to be made by an endorser. Like I mentioned, India has many such strong Bollywood personalities, or page three personalities as we call them in India, including social media influencers. Julika just brought this issue up from New Zealand about influencers. So we have those influencers here in India too. The celebrities, the experts in the domain relating to advertisements. So what does this particular provision say? Endorsers will be responsible to substantiate all descriptions, claims, and comparisons that they endorse in advertisements. Prior to this particular provision, the responsibility did not lie fully on the endorsers. Now it lies on the endorsers, and they have to be held responsible. The endorsements should not convey any express or implied representations that would be false, misleading, or deceptive. Any endorser who obtains advertising advice from an advertising self-regulatory organization or a legal opinion from an independent legal practitioner may be considered to have carried out due diligence. This is important. So this protects the endorsers who would be taking legal opinion from an independent person or legal person, and this protects them. What about expert endorsements? Any expert required to be actually utilizing his or her expertise in evaluating product features or characteristics which are relevant to the consumer of the product before endorsing it. A material connection has to be disclosed between the endorser and the trader. Manufacturer or advertiser of the endorsed product or services has to be disclosed. This is similar to the provision which Julika just mentioned in New Zealand, and India is taking very positive steps in this regard. With the COVID-19 outbreak, the government of India has taken measures, and very strong and drastic measures. And this actually came up because there was at least one herbal medicine. I don't know whether I can actually call it a medicine, a herbal concoction, a manufacturer who was trying to promote this particular product in the Indian market and saying that it was effective against COVID-19. So the government of India immediately sprung up and took measures which included preventing or prohibiting making false claims and making them punishable to prevent the spread of COVID-19 in the country. We have a ministry in India. This ministry is called the Ministry of Ayurveda, Yoga, Naturopathy, Unani, Siddha, and Homeopathy. It's called Ayush. That's the abbreviated form for it. Now, Ayush has prohibited publicity, advertisement of Ayush-related claims for COVID-19 treatment in print, TV, and electronic media. They just want to make sure that these particular claims are authenticated. There is scientific data. There are experimental studies. There are phase 1, phase 2, phase 3 trials that have been done before such claims, which can be false claims to a great extent, are promoted in media. Now, this is another very interesting topic, and particularly when it comes to India. Anybody advertising in India has to be careful, has to be cautious before, taking up such issues. Now, please understand, the regulation of advertisements on social media, digital platforms are not uniform in India. Again, I repeat, on social media, digital platforms, the regulation of advertisements are not uniform. There is lack of specific laws and specific enforcement mechanisms. But the basic principle that has to be followed is the advertisement should be non-offensive to public, or advertisement should be within the bounds of generally accepted standards of public decency and propriety. The video which is going to come in the next slide, which highlights what I'm talking right here. So a simple ad from a jewelry company, and this jewelry company is called Tanishq and belongs to the group Tata, a big group in India into all fields of, technologies or products, chemicals, salts, textiles, software, you name it. So simple, straightforward ad, and there was such a huge backlash against this ad on social media. In a few minutes, there was something like 17,000 odd Twitter messages, and they called this ad a love jihad. Now, if you had noticed this particular ad, it only shows a pregnant Hindu woman being married, who has already been married in a Muslim family, having a baby bash in a Muslim family. And this arrangement, this particular ceremony is for a baby bash back in India. And she's only asking her mother-in-law, who is a Muslim, these kind of rituals are not typically held in your home, are they? To which the mother-in-law replies, isn't it a tradition to keep daughters happy everywhere? Simple, straightforward ad. Nothing of the kind which the people back in India, just because it was an interfaith marriage, they call it a love jihad. So even in the absence of specific laws, enforcement mechanisms on digital platforms, the brands in India have to be careful not to hurt the deep-rooted religious sentiments of public, or they will have to face the backlash and go down to the hue and cry of public. The Consumer Complaints Council of Advertising Standards of Council of India held there was nothing wrong in this ad. It was not indecent, not vulgar or repulsive. But remember, you are dealing with India. So India has specific requirements, huge and high number of religions. And this particular interfaith relationship, either you can fight it out, like Tanishq preferred, Tata preferred to bow down, withdraw the ad, simply because all its 300 plus showrooms of jewelry in the country, gold jewelry or diamond jewelry, there were repercussions there. There were groups of people threatening to, shut down the shop or cause harm. So they decided that they are going to shut down this particular ad. They withdrew the ad and everything was at rest. So for a particular country, let it be any country in the world, you have to be careful how to move about. So even though the laws are in your favor, but you have to also take care of the people at large, and this ad was withdrawn. So with this, I conclude my presentation, and I hope I was able to give some insight into that. Thank you.
Hello, everyone. I'm Justina Zhang from TransAsia Lawyers here in China. Today, I will be discussing two issues. The first one is how pandemic impacts regulation and enforcement of advertising in China. The second one is how the data protection laws and regulations evolved with the pandemic. Let's get started with the first topic, how the pandemic impacts regulations and enforcement in China. Early this year, the regulator, in response to the pandemic, issued a notice on key points of combating false advertisement in 2020, according to which the regulator will focus its enforcement efforts in the following areas. The first one is cracking down on false advertisement concerning people's health and property safety, such as health food, medical treatment, drugs, real estate, financial investment, and financial management service. The second one is to strengthen supervision over emerging new forms of advertising. The third one is curbing false and illegal advertising on mobile apps and social media accounts. In the meantime, the regulation on advertising for drugs, medical device, health food, and foods for special medical purpose took effect on March 1st, 2020. This regulation reiterated the prior government approval requirements for drug, medical devices, health food, or food for special medical purpose. It also requires health food advertisements now to claim disease prevention or treatment function. The typical false advertising advertisement cases released by the regulators in 2020, mainly in the area of false advertisement for using the words such as prevent COVID-19 or improve immunity in advertisements related to drugs, medical devices, health food, health products, and some for even oral spray and tea. This is one of the cases that advertising its letters can improve immunities. The advertiser received administrative fines for false advertisement. This is another serious case that the advertiser falsely claimed that its mask or surgical quality. This is not only against breaches advertising law. The case was transferred to the public security for potential crime. Enforcement against the mobile apps continues during the pandemic. This year, it was Toutiao, a Chinese news aggregator Nasdaq-listed company, received expulsion from CCPA, that is Central TV Station of China, in its major event for consumer interest protection, namely 315 show, for including numerous illegal advertisements in its apps. The event shows how the false advertisements rampant on the mobile app of Toutiao. Here are two examples. The first one is a fake weight-losing products advertisement. It shows a fake comparison picture of how people using these products in 1 month and could easily lose 40 kilos. The second one is a false advertisement for financial management service products. It claims that you can earn 2,000 more per day, but actually it leads you to a illegal gambling platform. After the exposure, the app was removed from local Android app stores. During the pandemic, more consumers have begun shopping online in greater numbers and frequency than in physical stores. With the booming e-commerce, live streaming promotion by celebrities and influencers have grown phenomenally in China in 2020. Given its growing prevalence, it is no surprise that regulatory supervision and legal enforcement in this area also become more vigilant. This is one of the most controversial cases of live streaming promotion by the top live streamer Li Chie. When he calls the viewers to buy the non-stick pans he promoted and let his assistant to show how the frying eggs would not stick to the pan. Unfortunately, the pan failed the test miserably. The eggs were stuck firmly to the pan. Whether this was a false advertisement and should receive administrative punishment has been widely discussed. It also caused concern from regulators as to laws and regulations on live streaming for far behind the development of the live streaming technology, leaving many of the loopholes in the gray areas and may compromise consumers' interests. In respect of this emerging popular form of advertising, China Advertising Association issued its first self-regulation in June, namely Code of Conduct for Live Streaming Promotion. The code requires no false or misleading commercial publicity through live streaming promotion. Further, no false or fabricated transaction data or user comments could be used during the live stream promotion. In 1 month, the regulator also issued the draft guidelines on strengthening supervision on online live streaming market activities. That's a quick review of how the regulation and enforcement impacted by the COVID-19. The second topic I'm going to share is how the data privacy regulation and enforcement evolved in 2020. Cybersecurity and personal data protection in China witnessed rapid legislative development in recent years. Here is a brief list of laws, regulations, and standards issued recently. By end of 2019, the standards for methods of identifying unlawful acts or application to collect and use personal information were issued. In this year, we have a draft of a data security law issued for comments. We also have personal information protection law drafted for comments being issued. Especially in this personal information protection law, it addressed the long-concerned cross-border data transfer, also security assessment. In this draft, it stipulated that in serious violation case, it will be subject to RMB 50 million or 5% of turnover of last year. The comments of this personal information protection law ended mid of November. One of the milestones of a regulation was the civil code issued this year. The protection of the right of privacy and personal information for the first time addressed in the civil code as a separate personality right. Other than this regulation, we also have a security specification for information security technology. These specifications were used as guidance as to compliance with the security law in China. During the pandemic, facial and travel information were collected by Hesketh code to prevent the collec in China. Concerns have been raised as to security of personal information. Given that, the regulator clarified that all the personal information collected is encrypted and stored in government cloud and used for prevention of pandemic only. Further, it issued a regulation that no third party other than government can collect information in the name of the pandemic. During the pandemic, the legal enforcement against apps collection personal information legally has been continuing. In 2019, there were more than 2,000 apps were ordered to make changes for data collection, among which more than 200 illegal apps received punishment, including removed from App Store forever. The priority for 2020 have been illegal face tracking and other biometric information, abuse of permission to access voice and photos, and unauthorized uploading of personal information. The apps receive rectification orders from the regulator or even being removed from apps not only receive negative impact for its reputation, also compromise the effects of advertisement on its apps. Needless to say, understanding and complying with data protection law is very important for successful business and marketing in China. That's all I'm going to share about the advertisement and regulation updates in China 2020. If you have any questions, please feel free to send your questions to our panelists. You can easily find our contact in our Gala website and also our posts in Gala blog. Again, thank you everyone for attending this webinar. Thank you for the panelists for your great presentation.